Hello, everybody. Hello, Sofa Squad. Welcome back to the old sofa. I'm actually sitting on the chair, not the sofa, but it is what it is. How's everybody doing? I hope y'all are well. Y'all, so let's do our little stuff that we get out of the way in the very beginning. Hello, my name is Paul. I like long walks on the beach, the color blue. No, but for real, so this is the podcast channel, and make sure you're subscribed to this one. Make sure you're subscribed to the other one, depending on how you found this. All the links are down below. Let's give a warm sofa welcome to our lovely moderator, Emily. She holds things down here and kind of keeps me in line and everybody else. We do love her to death. So what we're doing today is this. So just I'm going to go ahead and pre-warn everybody. I worked all day long from 4 in the morning until about 6 tonight, but I was like seeing messages from people, all that kind of stuff. And then, I obviously knew jury selection day 2 was going on today. So I was like, okay, let's do that. Well, then obviously bombshell Daybell information, Aiden Fucci stuff coming out. So I was like, you know what? We're going to have to talk about several things. So here's how we're going to do the live chat. And it's going to be similar to what we did last night if you join me for last night. We're going to start off by going over Leticia Stout's day 2 jury selection. Pardon me. And we're just going to read some tweets by one of the reporters that was there and kind of go over that. After that, we will move on to Aiden Fucci and then Lori Daybell. Now, with those two, I've picked out some video stuff that we can watch. Well, one of them's audio or whatever, and we'll just see the vibe at that time. We'll see like where my energy level is, because I could be like at that point, but we'll see, depending on how deep we're going to talk about it. So we'll let everyone join. We're going to talk. We're going to say hi, and then we're going to jump into the updates on and just go over it. Now, I have not looked at this stuff yet, so I wanted to kind of just explore it with y'all and talk about it. This is commentary, so if you're not wanting to hear me talk and give my 2 cents and all that type of stuff, then you can find these videos. They're on YouTube, some law and crime, that kind of stuff. So on and so forth. Pardon me. And so there's that. Let's see what else. I hope everyone's doing good. Everything's going fine right now. Hold on, everybody. I don't know. Maybe look on the thing in there, but I haven't seen it. So I was going to say hey to everybody. Hello, Trisha. How are you doing? Hello, Erica and Miss Emily. Hello, Mel. Hey, Marsha. I'm sorry you had to miss one, but it's good to see your name. Hey, old soul. Hey, Marcy. Hey, CO. Hey, Trisha again. Hey, Vicky. Hey, Kathy. Hey, Warm-Hearted Journey. Hey, Peggy. Hey, Meredith. Marcy. And Lisa. And around noon. Around noon. I'm just going down the list here. I hope everybody's doing well. I hope y'all had a wonderful day. It was a long day at work. And so, hey, Sabine, I'm glad you're joining us. Excuse me. So it was a long day at work, a lot going on, y'all. But y'all, so much happened. I was like, oh my gosh, I cannot, right? So, we're going to catch up on it. So let me get over to the first screen. So what we're going to do first is we're going to go quickly over an article about Leticia. And then we're going to jump into the tweets. Now, as we learned last night, the tweets really didn't take that long to go over, right? Because remember, this is the jury selection at day 2, so they're in the weeding out process, basically. So yeah, there's that. So first things first, I'm going to present. Hey, Silent Observer. Yeah, the pollen. Oh my God, y'all. It's crazy. It's been so cold here, though. It's crazy. We're having like our second winter. Okay, we're going to share the screen. Leticia trial update, or no, is this it? Yeah, this one. Okay, so we're going to share. I'm going to make sure that y'all can see what I'm seeing. Now, I ain't the most tech savvy person, so just know that. Just know, okay? No shame in my game. So this is the second sanity report findings announced. I thought this was kind of interesting. We won't go through the whole thing. It's very quick anyways. But attorneys representing Leticia Stout revealed Tuesday that their psychiatrist concluded in her report that Stout was insane and in a psychotic state at the time of her stepson's murder, Gannon's murder. Please hold. The findings of the defense attorney's sanity report conducted by Dr. Dorothy Lewis were unknown until Tuesday when defense attorney Josh Cholini informed the potential jurors in the courtroom that his expert found Stauch to be insane. Of course she did. Uh, would she be in there if she didn't? You know what I'm saying? Court records, pardon me. Court records show that the report was filed to the court on Thursday after significant complaints from 4th Judicial District Attorney Michael Allen about not receiving the report at pretrial readiness conference earlier this month. She was probably waiting for the damn check to clear. She was like, "Look, we need to get this diagnosis going. Check ain't cleared. You know, we coughing up or what?" Allen said at Stauch's pretrial conference that if the report was not received before trial, the prosecution could move to exclude Dr. Lewis from testifying. Well, my God, you know that they were just shaking over that one, right? Allen said not having the report bordered on bad faith from the defense's expert. This is a disrespect to court deadlines, Allen said at pretrial readiness. I've never seen anything like this. The frustration from Allen was shared by Judge Gregory, who openly questioned how 13 months after Stauch pleaded not guilty by reason of insanity to all charges, and 7 months since Stauch's first sanity report was filed with the court, the defense's report hadn't yet to be filed. We would all like to know this, right? And now it goes on. Let's see. Are we going to get into all this? Let's see. Tuesday findings. Okay, so Tuesday marked the first time that the findings of the second sanity evaluation have been revealed. The woman conducting the evaluation, Dr. Lewis, is a former clinical professor of psychiatry at Yale University, the author of several books on the topic of the insanity plea. Pardon me, and the subject of the documentary, Crazy Not Insane. You know we have to look this up. Please help. We'll look it up after this. It's probably like a straight red box. I'm just joking. Okay, let's finish reading this. Featuring a straight to Redbox release. Coming to a Redbox near you. Coming to a grocery store lobby near you. Just kidding. Okay, let's keep going. The documentary outlines Lewis's work with notorious killers such as Ted Bundy, Arthur Shawcross, John Allen Muhammad, and many others. Lewis is expected to testify at some point during the trial. Okay. Okay, so let's go ahead and kind of dip into things, right? But let's first things first. Let's now I'm not gonna lie, y'all, and I'm gonna be as respectful as I can, especially because we're gonna talk about some serious stuff tonight, especially when we get into this. But yeah, if you follow me, you know I can. If there's something silly like that, I'm gonna, whatever. But okay. Let's look up this documentary real quick. Hey Charlotte, what's up? Hey Jess, how's it going? Oh wait, let me stop sharing that page. Okay, please hold. Okay, let's look this up real quick. And I'm slap happy. I'm not gonna lie, y'all. I've been up since 4 this morning. Talking about it's HBO. Okay, never mind. Hold on. I just had an idea. Please hold. Please hold. I'm looking this up for everyone. Okay, hold on. Now I'm not gonna like do the thing or whatever because it definitely will get this shut down. But no, and I'm also going to probably yawn a lot, and I'm sorry, but it's just because I'm tired. But it's not the company, okay? I swear. It's not, and I know it's rude, but I can't help it. I've just been up, but I want to look at this stuff, y'all. Okay, so let's look at this real quick, and then we're gonna jump into the things. But we're gonna look at this documentary, the HBO page landing page for it. So let's just look at that real quick, just to see like what it's about, right? Okay. Let me make sure y'all see the same thing that I do. Okay. Yes, you do. Crazy Not Insane. If you're just joining, this is the doctor who says that Leticia found her insane in the reports that were filed that you kind of like we first found out about it today. And this is a documentary that she did. Now, some of the subjects that she covers in here do sound interesting to me, all jokes aside. Well, that's really, can we get, really? Well, it's just the picture. My gosh. Okay, so watch HBO, Crazy Not Insane, watching HBO. It's 2 hours. It's from 2020, the year 2020. From Ted Bundy to Joe Rifkin, serial killers have fascinated Dr. Dorothy Lewis. from this film from Oscar-winning filmmaker Alex Gibney is a portrait of a woman willing to reach inside the darkest places of the criminal mind, featuring Dr. Lewis's literary voice read by Lauren Dern. The film reveals how she helped change the laws and approach of death penalty lawyers. It definitely sounds interesting, right? So definitely gonna, we're gonna give that a watch at some point. Okay, that's all I'm saying. Okay. Okay, sorry. Woo. Okay, here we go, everybody. Let's go to these tweets. Now, again, I tried to do a little practice before we got on the Twitters tonight. I know how to go through it a little bit, but it still confuses me. It doesn't take much. But I've got this dudes pulled up. We're going to read through them and we'll just work through it together. Again, if you're just joining, hello, how are you? My name is Paul. I live on the second floor. This is Leticia Stout's trial. We're going over that first. We're going to do Aiden Fucci next. And please hold. Let me share the screen with you. Share screen, and where are we? Zach, share screen. Dun, 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 dun. Okay. There y'all are. You can see the same thing I can. Pardon me. Okay, here we are. So this is Zach. He lives on the second floor. No, I'm just joking. I'm on a little thing with that tonight. Okay. Courts and public safety for the Gazette. He works for the Gazette. He's a reporter. He's covering this. He's one of many. And I like his style. I like what he's vibing. So here we go. Be sure to give him a follow on Twitter, Zach DuPont. Okay, so he says he's back in court today for the second day of Leticia Stout's jury trial, where attorneys will continue to work to find the 16 people who will serve on the jury for the trial. Expected to last 6 to 8 weeks. Let's see what the little thread shows. Now, this is one thing to help me out here. By me clicking that thread, is this showing me all the tweets from the day, from the whole day? Do I just need to read this one thread, or do I need to back out of it and then read the other ones along the way? Y'all help me out here. In fact, I'm going to come back over here because this was very confusing to me, right? Hey, Diana. I know, Emily, right? And it is that song. Look, I have forever had that lyric stuck in my head forever. Hey, Brittany. So y'all see what I'm saying about, do I click the thread and underneath and just keep reading that one thing? We'll figure it out as we go. What's important is that we're all hanging out here at the sofa. Okay. So Zach. So then the goal of the next 10 weeks is to find 110 people who could potentially serve on the jury. And on April 3rd, attorneys will pick the 16-person jury from that 110-person group. Yesterday, the first 20 potential jurors were selected. For anyone wanting more information on Stauch's first day of trial yesterday, you can read my recap story here. He gives the link. Probably another 10 to 15 minutes to get started. Issues again with most of the potential jurors, stating the length of the trial would be a significant problem in serving on the jury. On Tuesday, 39 of the 75 called in for jury duty indicated the length of the trial would be a serious issue. Now, for me personally, and this is one thing I found interesting, or that's interesting about this process, that would totally be an issue for me, right? It's kind of one of those things where it's like, I've got to pay bills and do this and do that, right? I work a normal job. So a case like this would make me panicky. Now, if you watched my live last night or follow me at all, you already know this is a particular case that I do not think I could put my bias aside like 100%. This woman literally sends fire ants through my veins of anger, right? I don't think I have it in me, right? And I do think that there are some cases where I could literally be like, well, let's put our reading glasses on and really just look at the letter of the law, and put our feelings aside. This ain't one of them. Okay. So So I'm sure they're going to run into that, right? Okay, let's keep going. A handful more said that the prior experiences with child abuse would make them wary of serving on the journey for this specific case. I feel you. On Monday, 48 of the 75 indicated the length of trial would be an issue. 23 people were dismissed after the morning break by Judge Warner, much less than yesterday, when more than half of the potential jurors were dismissed after the morning break. Josh Cellini, Stauch's defense attorney, just stated their psychologist, Dr. Dorothy Lewis, found Stauch to be insane at the time of the murder. The findings of Dr. Lewis's report have been unclear until today and weren't filed to the court at all until last week. Now, again, with this, I am so curious to know, like, why did it take so long? Right? I mean, why? Oh, and look, they do a little link for us. Let's look at it real quick. Please hold. Now, let me see if this works to where y'all can see this too. Can y'all see this? Okay, so what I'm going to do, you know what? We'll go read this after that so I don't get all over the place, right? So please hold. Let me go back to the screen. Okay. A lot of people, here we go. A lot of people today, like yesterday, stating there's no way they could be unbiased if selected to be part of this jury due to what they already have seen in the media and on social media. Then he goes on to quote, "My mind is made up and I am positive I can't overcome my bias," one person said. I mean, that would be me. 100%, right? 100% that would be me. I'd be like, dude, I can't do it, right? I mean, I wouldn't say it like that, obviously, in the courtroom, but, I'd be much more respectful of it. But I would be like, Your Honor, it ain't gonna happen. Okay, so let's see here. Okay, so let's go to the next thing here. Interesting difference between the 75 people called in today and yesterday. Yesterday, the majority of people who stated they had some bias eventually said they'd be willing to hear out the evidence and try to be unbiased. And I'm sure, like, once you get in there and you start, like, getting the vibe of the courtroom or whatever, and they go through this stuff, you might be able to be like, you know what, let me put this aside. Because at the end of the day, what you're doing, especially with this scenario, that I have to keep reminding myself that you're trying to decide insanity. Like, was she insane at the time of the crime? So she's admitting that she did it, right? Now let's just see. We'll see. Let's keep going. I have all these intrusive thoughts coming in that I want to go off in little left fields with, but we're sticking to the topic, and here we go. So today, most are indicating there's no chance they could do that. I've heard the sentence, "My mind is made up," at least 10 times already today. Not sure I heard it more than once or twice yesterday. Zach writes, tweets, whatever you want to call it. And again, I mean, listen to how I talk, where I'm just like, yeah, I mean, I don't think that she was insane. I don't even know what the legal definition of that in Colorado is, right? Just from what I've seen on the media. Now, mind you, obviously, me, people here, whatever, we follow this stuff more closely. So there could be people who are familiar with it, but not in the same context as like somebody like us who it's like we followed it. You know what I'm saying? Like, we have followed the whole thing. They might just know headlines like this horrific thing happened, but we don't 100% know. However, this is one of those that was hard and not to really follow it. Okay, no, wait, am I going the wrong way? Yes, this is what I did yesterday. So let's keep going back up here. I'm just looking right now to find, these are just talking about how many people remain. Let's see. I mean, is that it? Was that the big bombshells? Let's just see. I'm just kind of reading through this. I mean, it might not be anything major for today. My mind's made up post. And I'm sorry again, I'm just reading through this. Okay, so that appears to be all the major tweets here about today. Before we go to this next thing, let me check in with the chat room and just see what all is going on over here for that. Let's see. Yeah, I think, and so Rain, I'm just reading your post right here about you being on, what it sounds like a jury and whatnot. I've never actually served on a jury. Um, I think it would be fascinating. I've known many people who have. Um, you know, I don't know. Pardon me. And hello to everybody who's joining in. So what we're doing is we're just going through. We just read through the tweets from today's day 2 of jury selection for Leticia Stout. Now what we're going to do is just read a little bit about her psychiatrist or whoever has labeled her as being clinically or insane during the commission of the crime. And then after that, we're going to be talking about Aiden Fucci a little bit and some of that because that his sentencing is going on right now. And I want to actually look at a video on that one because I saw it and I was like, I'm dying to see how that sounds. So that's what we're going to do. Let's see here. Please hold. I'm just going to share the screen. First of all, is this? Yep, there's that. So let's share the screen. Now, what we're going to be doing is just looking more into Dorothy, not the Wizard of Oz, but Leticia's doctor. And let me make sure y'all can see this. Yep, there you are. Now, again, Wikipedia is not a very reliable resource, but this is the link that he provided here about her. So, let's just see the basics of it, right? But this is a grain of salt type thing because if I'm correct, Wikipedia, anybody can go in there and do stuff to it. And now we're not going to get all up in it with it, right? Okay, so Dorothy Lewis is an American psychiatrist and author who's been an expert witness at a number of high-profile cases. She specializes in the study of violent individuals and people with dissociative identity disorder. Now, we already know, formerly known as multiple personality disorder. Now, we already know Leticia pulled that whole peanut butter stunt. All this like random stuff, right? So there's that. Lewis has worked with death row inmates as well as other prison inmates convicted for crimes of passion and violence. She was the director of the DID clinic at Bellevue Hospital, associated with New York University in New York City, professor of psychiatry at Yale and New York University, and is the author of Guilty by Reason of Insanity, a book she wrote on research done in collaboration with neurologist Jonathan Pincus. So, I mean, she sounds like her accolades are, pretty good sounding. She served on Mark David Chapman, Joe Rifkin, David Wilson, Marie Moore, Joseph Paul Franklin, Ted Bundy, and Arthur Shawcross. So then, you know what we're going to do? You know what we're going to do real quick, everybody? We're going to just look up and see what she looks like. Okay, for no other reason than just pure curiosity. So let's just do that real quick. Let's see here. Dorothy. Is this Dorothy? Okay, so let me share this with y'all. Oh, thank you, Irene. I appreciate it. And hello and love to your pugs. Share screen. We're just finishing. We're not finishing up. We're kind of just going down a rabbit hole in some of the Leticia Stout stuff. I'm getting ready to show you a picture of her psychiatrist. Now this is an older one from an article that they did on the documentary that she worked on or whatever. But that's her. Looks like testifying in court at some point in time, and see where it says they were not born evil inside a troubling film on why people kill. It probably actually is interesting. I know I was joking about it being, there she is right there. I know I was joking about it being a, what do you call it? A straight red box release. I'm just joking. Because here is my concern, and this goes for anything. When you get into situations like this, I want to hear the evidence of this right here. I also want to know what kind of money are we talking about being paid, that type of situation. I think we need to watch the trailer. I don't know. It could get us in trouble here. I don't know. We're going to try. But we'll see, right? So here we go. You know what we're going to do?
It's fascinated me. I think any one of us, myself included, could kill. Don't you ever wonder why you don't murder? We know that the most disturbed, the most psychotic, or the most brain-damaged killers do the most bizarre, grotesque, horrendous kinds of things. Courts are all far more curious about what the murderer did than about why they did it.
This does sound interesting.
I'm wondering how someone could do that to someone else.
Yeah.
It appalled me and it fascinated me.
I mean, I get what she's saying.
And pioneers are often not treated well.
It was early in my career. My work was questionable.
They did a form of interviewing that can cause vulnerable people to believe they have more than one personality.
How can there be such different functioning in the same brain?
Bundy himself perpetuated the fantasy that he came from this perfectly normal childhood.
So I interviewed family members. Things were horrendous for Bundy from conception onward. When you couple some kind of brain dysfunction with a history of horrible early ongoing abuse, the social, the psychological, the biological forces that came together, you get a super dangerous person.
So I'm very curious to see what she has to say about, who is it? Leticia. I think I've seen this. I feel like I've seen this, right? I just do, and it's been a minute, but it was 2020, so it's a few years ago, which it doesn't seem like yesterday. So yeah, it'll be interesting to see what she has to say. So that means that, okay. Now, let's move. Oh, first of all, let me stop sharing. Okay, so first of all, if you've just joined, welcome. How's everybody doing? So what we've done is we just finished going over some of the Leticia Stout stuff, and now what we're going to do is we're going to move on to the Aiden Fucci sentencing. So what I want to do with that is, first of all, I want to see what I pulled up, because I came home and basically pulled up a bunch of stuff, and I was like, I want to look at this and this and the other, and so we're just going to pull this up real quick. I'm going to come over here and look at it. Yes, okay. Okay, so let me get rid of the screen so I know we don't need anymore, right? We don't need that. Here we go. First of all, I'm going to pull this up. Now, one thing I'm going to try and avoid when we do a little quick overview is talking about the actual, injuries and stuff like that. But I don't know what's in the video that we're going to watch, right? So if it gets to whatever. So basically, overall, this is a trigger warning, right? Because this is horrible. This was there were two young people, right? Himself and his victim, Tristan Bailey, who he stabbed to death, and he has pled guilty. Basically, he's throwing himself at the mercy of the court, right? And so his sentencing is going on right now. Now he's a few years older. I forget. I think, what is he now? Is he like 15 or 16 or something? He's still a kid, right? And it's gut wrenching, right? I mean, what he did to this young lady, this child, I should say, is, it's horrendous. So anyways, there's that. Let's read a quick article over it. And then I saw that they did a video today on, where is it? Aiden Fucci grilled by his own parents about the night with Tristan Bailey. It's like in an interview room or something like that. And we're going to try and watch it and see what it is. And there you go. So here we go. Please hold. Okay, we're going to present to y'all. We're going to share the screen with y'all. We're going to continue to share the screen. Grim medical emotional victim. Yeah, this is it. Okay, let me make sure y'all can see what I'm seeing. There you are. Okay. Again, slapping this with trigger warnings, y'all. Slapping it with trigger warnings. Grim medical examiner testimony, emotional victim impact statements on the first day of the Aiden Fucci sentencing. Here he is, still looks like a little kid. Pleaded guilty to first-degree murder and 13-year-old Tristan Bailey stabbing death. Aiden Fucci, who pleaded guilty to the first-degree murder and admitted to killing his 13-year-old schoolmate Tristan Bailey in the early morning hours of Mother's Day. I mean, come on, right? Seriously. 2021 will face a judge over the next several days before learning his fate later this week. He could spend the rest of his life in prison. As a juvenile, when the offense occurred, he is not eligible for the death penalty, and his sentencing hearing will not involve a jury. The hearing ended Tuesday with the start of victim impact statements, beginning with tearful testimony from Tristan's all-star cheerleading coach, Brianna Cherry. She said she called her athletes her cheer children and that Tristan was special and would be missed every day. Our team lost its leader. These teammates lost their sister, and I lost a piece of my heart that I can never get back. I mean, gives me goosebumps. Oh, my God. I cannot imagine. Okay. Let's just keep looking. And there she is. Here's Tristan. A family friend and a mom of Tristan's classmate who said Tristan touched her son's life by reaching out to him at school also shared heartfelt victim impact statements. Now, here's the thing. I'll say this. We're not going to go through and read all the stuff about the injuries and stuff like that because let's just not do that, right? But here we go. With finishing the paragraph I was reading. Tristan Bailey's family wore aqua as they sat in the courtroom gallery Tuesday, listening to disturbing testimony about the moments before and after her brutal death. 6 members of her family will share victim impact statements Wednesday morning, and then the defense will present its case. Several juveniles will be testing Wednesday, and News4Jax will not be showing their faces, so their testimony will be audio only. So it goes into this. Now, I will just say this. He said that the medical examiner person apparently was saying that she was fighting. So she put up a big fight. Now, I will read this right here. He had told a friend to expect me to kill somebody this month. Fucci said he would walk around at night, drag them into the woods, do things to them that pretend he didn't do it so he could keep killing people. He verbalized to peers very descriptively and similar to what happened to Tristan Bailey. I would say that suggests to me some rehearsal, perhaps premeditation, Pritchard said. Even if you didn't have that premeditation, though, he did clearly. It's there. It's in its head. It just goes on here further. The crime scene photos and analysts, the stain on Fucci's shirt came back as connected to Fucci. And there he is in the thing. Now, if you remember, this was like if you're seeing, looking at this now, I mean, this was like when he was getting arrested, right? Snapchat's become so prevalent and all this type of stuff. These were recovered from his account the day he was arrested. An undercover investigator testified about conversations captured on video between Fucci and his parents when he was taken into custody. Now, we'll let this segue into this right here. So I'm going to stop sharing because I haven't seen these yet, right? So I wanted to listen to them. Now, for this is one, if you want to see this without me talking about it, check it out on Law and Crime because that's where it's at. Because I'm probably going to stop and do all that kind of stuff, whatever. So just know that. So just, be aware. I'm going to present to y'all. I'm going to share the screen. Okay, where did it go? I kissed her, Aiden Fucci. That's up. Share. Let me see if y'all can see everything. Okay, there we go. Here we go now. There's that and right.
Then you respond.
This is very serious. I mean, you can't act like I don't know. I don't know. You can't
You
say
understand
nothing.
this is serious?
Can y'all hear it okay? Can you hear me okay? Can you hear that okay? Is everything kind of leveled out? Drop a 1 for yes, 2 for no.
That Snapchat you get this number is
No. Now we have people on the phone or house, not in their car because of that Snapchat thing you did. You're all over the internet everywhere. Social media.
It is on social media. You'll probably come stay with me after we get done with this, just for your well safe being. Yeah, no stress, nothing like that, right? No, sir.
Thanks for everybody for the letting me know.
You should all Stout. Thank you so much.
I don't want to sit. I know my hands so bad.
I mean, I guess this is my. Can you imagine his parents? I mean, you just found out your son. I mean, my God. This is like monster stuff that he did, right? Yeah. Do we know? Peggy says, "Do you wonder what his home life is like?" I do wonder. Like, have we heard? I mean, does anyone know? Like, have we gotten any intel into this? Like,
You just tell me anything different than our car that we don't know about? No. You don't want to pick this girl up. Pick up?
I'm talking about her dealer.
You think she got picked up by him?
Probably. She said she wouldn't come home. She said she's gonna find somebody.
Like she left her there walking? Like you think she got picked up after that? She just kept walking?
Probably. Yeah, I don't know.
Do you know if she turned the other direction or she was just still walking behind him?
She pushed her down and you walked away. We shouldn't be talking.
I just asked what he told the cops.
I understand.
I just asked what he told them.
As you walked away, you came straight home. You didn't turn back around and see where she went. What were you doing outside that late at night? I was at Trey's house, with them. Did you kiss or do anything with this girl?
Be honest as you can to them.
Two.
Yes.
Yeah, I kissed her. Any further? So your DNA's gonna be on her. You saw your shoes were off on the camera. While your shoes off. Get my favorite her. She's giving blisters.
Did you come home and leave again? Did you sneak back out or you're still at Trey's house all day?
I was at Trey's house.
It's just the one night I didn't ask where you were. So sorry.
yeah, right now they're in the sentencing phase for him.
This is serious. Man.
It's very serious.
This is no joke. This is your whole life. Your whole life.
And hers.
And ours. And your brothers and sisters. And don't forget you're going to school alone.
Why?
Because the kids will hurt them. You're going to keep me, right?
They don't have no evidence that I know of yet. Unless you know any other thing I don't know. Did y'all have sex?
Did she really grab you and you just really pushed her, or was that?
No, she did. You don't know what happened to her after you pushed her?
Did she say ow or get mad?
She said Aiden. She was like, Aiden. think I pushed her, but I told her to act on. And she went.
The only direction she wanted?
Probably the other way, because she wasn't next to me anymore.
You didn't look back around?
Mhm.
I mean, this is painful to watch, right?
Nothing to worry about, right?
Mhm.
So he's just thinking, I guess, that he's just going to lie his way out. I mean, this is what, a 13, 14-year-old at this time?
They're searching our house right now.
Why were you down?
Mhm.
Were you up and down?
Hey, Pauline.
For what?
No water.
For water?
Water from the cup.
Her cup?
No, water from a cup. A drink.
You spilling yourself?
Mm-hmm.
Why?
I mean, it's almost like they caught him smoking. He's treating it like that. Almost like, those weren't my cigarettes. Like, just that, you know. There's just something so off with it, right?
What is it? I had a nightmare.
Still looking back at home.
Me too. Can we go home and get your clothes?
More clothes.
The clothes you're wearing?
Mhm.
Yeah, I'd be freaking out too. 100% if I was him or them. But it sounds like she keeps saying stuff like,
Those clothes are up.
Mhm.
it sounds,
Khakis or blue?
And blue jeans.
You sure of that one?
Mhm. Mhm.
yes, the subtitles. I'm so sorry I didn't do that earlier. Oh my gosh. Wait, I don't think it has it. Oh, it's unavailable. Oh my gosh.
Mhm.
I mean, and it sounds like the mom will say things like, when we, correct me if I'm wrong, when we go home, like talking like that. Oh, look, there he is. There he is. There he
Did you
is.
see this 20-year-old kid? You didn't get his water
Mhm. I've never even saw him before. I just heard about him.
that night?
Hmm?
You just heard about him that night?
I've heard about him many times.
Do you have the black card?
I don't know.
Are you not scared?
Not really.
Not really?
I'm a little scared, but
If he didn't do nothing, I would be worried about him.
I know, that's what I was asking.
He didn't do nothing, right?
gotcha.
It's a hell of a bad time, bad spot.
The guy knows if that's his biological dad.
A girl by herself in the middle of the streets at 2 o'clock in the morning, or whatever time, is not smart, bro. part either. You stay away from females. Anything could happen. Did you kiss her this night?
Mm-hmm.
This last night?
Mm-hmm.
Right, Trey's house,
Mm-hmm.
on a walk. I was gonna see why you kissed her and all of a sudden she grabbed you and you pushed her.
You better find your story and stay tuned. Think about every question he's going to ask you. Before you answer it, you think about the answer again. The next hour or two.
You're gonna make a phone call, ask him the same question, and make sure he gets the same answer. I'm gonna badger you, badger you, badger you, badger you. Your answer changes.
See, they're telling him how it's going to go.
Reading goes off a little bit. Probably down the way right now.
Who's your phone?
I'm the officer.
Did you get your food at least?
Mm-hmm.
I know what you get you, so I got you back in there.
That was good.
Did he ask you any questions inside the car?
Mm-hmm. Just about what I look like.
Did you tell Dylan to get Preston?
No, Jacob, and, you don't wanna pick on him until you left the house to get him.
Yeah, this is almost like a time of, boy, you need to sit.
They sent 2 hours to do the autopsy.
Hold on.
What's that?
Hold on. Where is this?
Did they ever say, why it took you so long to get home?
Mm-hmm. They asked me why. I just said I walked home.
By yourself?
Mm-hmm.
Did you just walk really slow home?
Mm-hmm. I didn't want to slow everything down.
Okay, so, yeah, wow. Fire hot. Alrighty. Yeah, so, okay, I'm in there with you. I could barely understand a lot of what they were saying, too. And the closed caption didn't work. I was really upset. Whew. Okay. Yeah, this is a situation of, boy, you need to pick yourself up, shoulders back, chest out. Now, he was saying yes, sir. We need some yes or no's up in here. Get your hair out of your face. You know what I'm saying? Let's act appropriate to where we're at. We are up in the damn interrogation room. Not talking about, did you use your ID to buy some alcohol over the weekend? We're not talking about, did you skip school one too many times this year? We're talking about international headline horrifying crime to your schoolmate. Okay, this is really, really bad. And yeah, the reaction to the parents. Now, I had forgotten about the whole level that the mother washed the jeans and all this type of stuff. You know, clearly clearly you can see, and again, this is my opinion. I am not a psychiatrist. I'm not any of this stuff. Y'all know this, but I have to just say it, obviously, right? You get it. You can clearly see the dysfunction going on, right? This boy is closed off. This is, yes, okay. When I was walking, well, she pushed me and, this happened. And you know what I'm saying? Now, again, first of all, I don't expect a kid to do something what he did. But secondly, I do expect a kid to think, well, it'll just kind of go away if I lie about it. You know what I'm saying? That type situation. And that's kind of what I felt, because I'm just like, with the parents, I'm like, I mean, this is really bad, right? I mean, there's like, at this point, this is no turning back. And I think maybe they're coming to terms with that, because again, as a parent, or even, I mean, even without your parent, your brother, or whatever, any of this stuff, if you're in the room with someone in this situation that you are closely connected to, but especially a child, and you're like, okay, uh, uh, this is happening. This person I know did this. You know what I'm saying? It's really, really bad. So I want to look this up, because one thing I was thinking was this. And the lack of emotion just kind of gets me. Now, reading from the comments and stuff that was going on, it does sound like maybe there's some other issues going on within the family, maybe some legal problems. So maybe there's already this is going on. You know what I mean? Just there's stuff taking place that could definitely be part of this right now. I want to see this real quick, because remember, he's so young, and this is Florida, and I feel like they did pass laws that it's like, if you are an offender his age, yeah, we already know no death penalty, but it's almost like you're guaranteed or something like that, to get like some kind of parole possibility or something like that. But let's look at it real quick. Florida laws on youth offender first degree murder. Okay. Please hold. We're consulting the oracles. Well, this is all different. I mean, but you limited life without parole, homicide offenses, ban the use of mandatory life without parole. Okay, so this is a whole other research thing to go into, because this says they can get the death penalty. This says they can't. This says that they can do a life without parole. This says it can't. I don't know. Okay, I don't know. I think that I think like a lot of these things, he will, things will come up along the way through the years, because you know how it's like, let's put it this way. He ain't going home anytime soon. Okay. Um, he ain't going home anytime soon, but in 20 years, he might be like, okay, look, we've changed some laws. We're going to go up in here now, and we're going to talk about, we're going to give them a chance, and they might see what happened. But this is one of those things right here. This is one of these cases right here. Good luck. Okay. Good luck. Remember some of the Manson girls that I think that, are any of them still alive anymore? And I'm not talking about Manson himself. I'm talking about the people who were physically there, did the thing. They were in jail forever, right? Because I mean, it was just horrific, right? And that was California, which even for California, I was shocked that they kept them in there that long, right? I'm like, please, like you can literally pretty much do anything in California, right? And they're just like, well, come on, just stay a few days, go on back out there. It just seems how to go. They're so overcrowded over there. So that's, anyways, Aiden Fucci's thing is going to continue to go tomorrow. So there's that. Now, what we're going to do to finish this off, pardon me, is I'm going to yawn at you. Now, if you've just joined, I apologize. I've been up since 4 this morning. I went to work all day long, and then I was keeping up with all this stuff during the day, like, when I could. And so I was like, I want to come to the Sofa Squad and talk about it. And so that's what we've been doing. So I apologize if I yawn, if I fall asleep, or anything like that. Lori Daybell. Y'all. Yeah. Now, I want to give a shout out to, hold on. Let's claim your damn fame if you're out there. Good Lord. Watch, it won't work right now. I'm trying to be all quick and swift about it. Because I want to see if I can do this here. I can't find her name now. I was going to give shout outs to the person who broke the news to me about Lori Daybell. And I want to see it's Izzy. I feel like it is. Izzy, if it's you, claim your fame, girl. And thank you. I do check on this stuff when I can throughout the day, so I appreciate y'all. When I saw the death penalty stuff, I was like, I kind of saw it coming, right? Because it was like, it just, when I say made sense, I just kind of, it made sense in that way. And so when that was announced, I was like, okay, well, here we go. So this is the next thing. I have the video pulled up. I'm sorry, the audio from it's with the East Idaho News. So I figured we could go through it because I haven't listened to it. It's only 36 minutes. But first, let me see if it's pulled up. Please hold. Let me see if I got it up still. Well, Rudy too. I guess I don't. That's fine too. So let me share the screen with you now. So what we're going into now is audio of Daybell hearing from today on the death penalty. And if I can find the present button, which here it is. We're going to share the screen. We're going to come over to y'all. Audio from Lori. There we go. Let me make sure y'all can. I guess it doesn't matter. It's just an audio thing. We're going to do this. The closed captionings work, but this sounds much clearer, right?
This is ACR 22-21-1624, State versus Lori Noreen Vallow. Representing Ms. Vallow is Mr. Archibald and Mr. Thomas for the defense.
Can y'all hear?
States here represented by
okay,
Mr. Wood.
okay.
Ms. Rawlings is here. Rachel Smith also for the prosecution. I believe Lindsay Blake was intending to appear by Zoom. Has she been?
Yeah, the audio on this is amazing. So at least we know
well, to
we
the
have
extent
that.
she can make an appearance there, we'll try to transmit this decision through the Zoom proceeding as well. The court would note as we get started here, there is an order governing courtroom conduct.
How
I
is
would
that,
ask
everybody?
everyone
Can
to
y'all
please
still
comply
hear
with
it?
that
How
order,
does that
specifically as it relates to parts 2, C, and
Hey,
D
Michelle.
regarding the use of cell phones or electronic devices, that there's no recording permitted throughout these proceedings, either audio or video. And please have your phones in a either silent or off mode so that they don't interfere with any proceedings today.
Thanks for watching, Rock.
Was here last week on motions filed just on the eve of trial from the defense. The court took under advisement motions in order to have time to make rulings today, which the court will do in an oral ruling.
She was smiling when she left that courtroom.
Under advisement were a motion to compel, which was filed by the defense March 7th, and the state's response March 13th. There was a rebuttal to that filed March 14th, and the court heard argument on that motion to compel. At this time, then, the court is
I'm sure
prepared to make ruling on the motion to compel. In essence, the motion asked the court for an order compelling the disclosure of all information that was sought by the defense in a discovery request that was filed in the case on August 9th, 2021. Some procedural history there. There was an order appointing Mr. Archibald on August 6, 2021 as the attorney in this case.
Yeah, she's going to
There was
be.
a first supplemental discovery disclosure provided by the state on August 9th, 2021, notifying the defendant of
She always has that weird
statements
smile
of the defendant.
like she's been in the portal
The
for a minute
disclosure
too
also
long. You know what I'm saying?
identified what was, quote, defendant's jail phone calls and visits.
Like the
There was
portal's got her
also
crispy around
responses
the
as to
edges.
statements of co-defendant, which also referenced, quote, defendant's jail phone calls and visits, and the defendant's prior records, and those had been previously provided to the defense on a July 15th, 2021 disclosure, according to the state. The court considered the state's response to the request for discovery. There was a notification by John Thomas that the discovery in the above referenced matter was provided to co-counsel Mr. Archibald August 16, 2021 and November 22nd, 2021. In the hearing we had on
Yeah, she's
March
overcooked.
15th, 6
They
days
put her in
ago,
that damn
the
crisper.
counsel for the defense stated unequivocally that the state on Monday, March 13th, had given the defense recordings of jail calls and visits, but also argued that there was no time to fully review those and investigate if anything needed to be investigated. As it relates just solely to the motion to compel, based on the request that any additional items be further disclosed through discovery, the court does find that the state did comply by providing the responses requested through the motion to compel. And so, based on argument and what was represented on the record, the court finds at this time it's not necessary to order any compelling further of discovery, as the state's indicated it's been provided. So the defendant's motion to compel is denied. And I'll mention to counsel, obviously, I've got quite a bit to say here today, and this will be oral rulings, which will be preserved on the record. We do have the court reporter here as well as the FTR recordings, and I won't be requesting any orders to be submitted from counsel. The court will take care of the orders that will flow from the rulings made today. The other motions court took under advisement was a motion in limine to exclude late disclosed evidence. The court has gone through that motion in limine to disclose the late disclosed evidence, and in lieu of an oral ruling on that today, the court is going to issue a written ruling which will address the specific items sought to be barred in the motion in limine, and a written ruling will be provided to the parties, should be no later than tomorrow on Wednesday, the 22nd of March. Final motion then the court will consider today is the motion to dismiss the death penalty. That was a motion filed on March 5th, 2023, and seeking dismissal of the state's notice of intent to seek the death penalty that was filed in this case on May 2nd, 2022. The court did determine the notice was timely filed pursuant to Idaho Code 18-4004A. I'll just note at the outset too, I recognize a late filed motion to provide additional evidence to the court was filed yesterday. I'm aware that that's been filed, and I'll address that at the end of the decision that I've made here now. Going back procedurally then to the motion to dismiss the death penalty, the motion cites 4 bases in support of the argument to dismiss the death penalty in this case. Number 1, media saturation. Number 2, multiple discovery violations by the government. Number 3, an argument that the defendant's mental status should preclude the death penalty. Number 4, an argument regarding the inability of the state to effectively administer the death penalty if the jury decided to impose it. The state filed their objection to this motion on March 13th, 2023. The state argues the motion is not ripe, that media saturation is not a valid ground for the relief sought, that the alleged discovery violations do not warrant the relief sought, that capital punishment is a constitutionally available sentence in Idaho, and that the manner in which the punishment may be administered is not a ripe issue. The defendants then filed their response to that motion March 14th, the following day. So that was a week ago. Contained in the response was a supporting affidavit of Mary C. Goody, who is a defense team mitigation specialist on the defense team. In her affidavit, there were a couple of statements and comments in there. Paragraph 18, she says, quote, "The recent disclosures make reviewing the complete discovery information frankly impossible." Paragraph 19, quote, "Should this additional discovery be allowed, I would be further precluded from conducting my customary and reasonable mitigation investigation into Lori Vallow Daybell's case. Allowing in any of the state's new discovery after the discovery cutoff date prevents me from conducting the type of mitigation investigation which adheres to the prevailing professional norms of practices in death penalty cases." At the outset, this court has considered the arguments in the motion to dismiss the death penalty relating to media saturation, the defendant's mental health, and the ability or inability of the state of Idaho to currently carry out a death sentence. The court notes that also under advisement are motions challenging the constitutionality of Idaho's death penalty statute. Those arguments will be addressed subsequent to the court's analysis of the argument that late disclosed discovery in this case merits a sanction of the dismissal of the death penalty, and this decision will focus on that argument. The court will now review the argument related to the alleged discovery violations in this case. There's a pertinent timeline that the court's considered in the case. There was an indictment returned by a grand jury on May 25th, 2021. The defendant was arraigned on April 19th, 2022. The state timely filed a notice of the intent to seek the death penalty on May 3rd, 2022. Court sent out a amended scheduling order after a January trial had to be continued. And in that order, a pretrial conference was scheduled and held on February 23rd, 2023. At that time, this case was joined for trial with a companion case, State versus Chad Daybell. That's case CR 22-21-1623.
I would
And the
too,
court
Jenny.
ended up granting a severance motion.
That channel would go
severing the
viral.
cases on
Jenny says she paid good
March
money for a
2nd
pay-per-view
of
channel of
this
Lori
year.
and Leticia being forced to live in a small cell
The
together.
court would note that before the severance
They
of the
talk
cases,
each other to
both
death.
of the defendants began complaining about the timeliness of discovery disclosures provided by the state, arguing that large volumes of discovery were occurring late in the proceedings, impeding the ability of the defense to prepare for trial. At the February 23rd pretrial conference, defense counsel stated concerns about being prepared for trial due to recent discovery disclosures. Counsel for Mr. Daybell in the companion case stated unequivocally that he would not be ready for trial because of recent voluminous discovery disclosures. This issue again came before the court 19 days ago when the court ordered a severance of the two cases for the trial based on recent disclosures of DNA evidence that led to a determination that the companion case had to be continued to allow for additional DNA testing. Importantly, in that other case, Mr. Daybell waived his right to a speedy trial, and the defendant in this case has not. Last week, on March 15th, the court held another hearing, again largely focused on the issue of discovery disclosures and an argument of the defense
Yeah, Letitia's got
that they had
feral,
received late disclosures past the court-ordered deadlines, and that they
she
were
might
now in
gnaw
fact
Lori's arm off
prejudiced
overnight.
by those late disclosures.
Kind of a thing.
The court took those issues under advisement for ruling at the earliest opportunity we had, which is a ruling made here today. The court reviewed the history of the discovery requests and disclosures in this case. There are three categories relating to the disclosure dates. There are disclosures of discovery that were made before February 27th, 2023, which are deemed timely under the court's scheduling order. There were disclosures made on February 27th, 2023, which were late in that the scheduling order expressly stated that the discovery had to be completed prior to February 27th. And there's a third category of disclosures which occurred in March of this year, which were inarguably late and past the February 27th deadline for discovery. The courts considered the argument of the state as it relates to that February 27th deadline. While the order is clear, the state argues that it was led to believe that the February 27th date was in fact the deadline. In considering this argument, the court determines that the disclosures made February 27th were in fact late, but considers the state's good faith explanation and mitigation when determining whether prejudice has resulted due to the time those disclosures were made. However, the court also must consider that additional disclosures were made well after the February 27th deadline and are inexcusably late. Notably, there were provided to the defense for the first time recordings of jail calls and visits, which include both statements recorded of the defendant and the co-defendant. Still pending out there also are potentially new DNA results.
That will be
with the
interesting.
disclosures of those 100 plus hours, as it's been represented, of jail phone calls of the defendant and co-defendant were
Those will
clearly
be
past
really interesting.
the deadline. So the court now must consider, pursuant to Criminal Rule 16E2, well, I'll cite a case here, which is State versus Matthews 124 Idaho 806. And that says, pursuant to Idaho Criminal Rule 16E2, and I'll note that's now Rule F2, the rules have changed. The court is authorized to impose sanctions for discovery violations. See State versus Merrick, 112 Idaho 860, 1987 case. The choice of an appropriate sanction for failure to comply with a discovery request is within the discretion of the trial court, and the trial court's exercise of that discretion is beyond the purview of a reviewing court unless it has been clearly abused. And that's, again, the State versus Matthews case, 124 Idaho 806. Courts reviewed Idaho Criminal Rule 16K, which cites to orders for discovery. If a party has failed to comply with a request for discovery under this rule, the court, on motion of a party, may, number one, order a party to permit the discovery or inspection. Number two, prohibit the discovery of part or all of the information, evidence, or materials sought to be discovered. Or number three, enter such other order as it deems just under the circumstances. So the court does have a statutory or a rule-based and case-based precedent for imposing any sort of sanction as a result of discovery violations. As an initial determination here, this court does find that there have been discovery violations in the case. The defense argues there have also been Brady violations. The court has reviewed the record and determines that at this time, there's no indication that the state has violated either Criminal Rule 16A, which requires mandatory disclosures, or Brady, as there's no evidence that tends to negate the guilt of the accused as to the offense charged, or that would tend to reduce the punishment of the offense. No evidence of that nature has yet been identified specifically. The problem here is a timing problem. The problem here is that both parties cannot be certain whether or not there is exculpatory evidence or mitigation evidence within the late disclosed discovery. The defense argues that they cannot review the late disclosed evidence because there's simply not enough time remaining before trial to do so. The state conceded at the hearing on March 15th that even the prosecution likewise would be unable to complete the review of all discovery before trial. The court cannot and will not engage in speculation that the late disclosed discovery does not contain any exculpatory or mitigating evidence. If the final discovery disclosures had been submitted by the state to the defense on February 27th, and that was the end of the disclosures, it would be difficult for the court to determine that prejudice would arise from potentially a one-day miscalculation. However, even more discovery and a significant amount was further disclosed even later. On March 7th, just 14 days ago, a motion to compel was filed by the defense requesting further disclosures of information previously requested by the defense going back to a 2021 filing. In response, the state produced a supplemental discovery disclosure on March 13th, 2023, producing those, what I'll refer to as jailhouse recordings. The parties have represented to the court that over 100 hours of previously undisclosed recordings were provided to the defense. The state concedes that this late disclosed discovery was due to, quote, an oversight within the offices. In order to determine if a discovery sanction is warranted, the court has to consider whether there is in fact now prejudice. A Brady or Youngblood is another case. Analysis is not required to reach that decision here, as the fundamental consideration is the right of the defendant to meaningfully prepare their defense and the duty of the state to comply with court-ordered discovery deadlines. As has been argued throughout this case, death is different. Here, the defense argues there is actual prejudice due to the late disclosed discovery and that it is substantial and material. The court has considered the arguments of Mr. Archibald. Mr. Archibald urged the court to consider that he typically receives discovery in a timely manner when dealing with the prosecution in other cases and does not have these discovery-related issues. And the court, based on my experience, I agree with that assertion. I've dealt with Mr. Archibald in hundreds of felony cases, including other murder cases. I can't remember a single case where Mr. Archibald filed a motion to compel or argued for a discovery sanction until this case. Mr. Archibald has established a pattern of credibility with the court that I consider when hearing his arguments that there is in fact prejudice.
Interesting.
Likewise, this court has also dealt extensively with both Mr. Wood and Ms. Blake in hundreds of felony cases. And I find that both Mr. Wood and Ms. Blake are honest prosecutors and forthright in the duties they undertake as prosecutors, and I have no reason to question the integrity of the prosecution in this case. As has been demonstrated in this case, they've continued to disclose discovery even when they knew it was beyond the deadline, because they have followed their ethical responsibilities in this case, as they do in all of their cases, in my experience. Upon weighing the arguments of counsel and considering the record, the court must determine here that the defense has in fact demonstrated material prejudice resulting from late disclosures. The prejudice has occurred because of the proximity of the trial, the volume of the discovery, and the inability of the defense to adequately review that discovery before trial begins. In a case called U.S. versus Rivera Clemente, a federal court held that the failure of the government to fully disclose all discovery resulted in prejudice. The court further stated,
do we
quote,
think that it's
moreover, in a
just
death
too much
penalty
for the
case
state?
where the
You know,
stakes
it's
are
just
so high, a
overwhelming,
smaller
and that's
quantum of
why
prejudice may justify a
this is
sanction.
going on, kind of a
And that
thing.
also cites a different case, Lopez Matias 522 F3rd 154. Having determined that prejudice has resulted due to the late disclosed discovery, the court must next consider what course of action, if any, is
You and me
necessary.
both, calcification.
First, with the defense having timely raised the issue, the court determines that if I were to fail to address this discovery issue, I believe this case would inevitably be reversed on appeal if there was a capital conviction. With the defense assertion of prejudice, the court must determine what is an appropriate remedy. Here, because the court has found or has not found any willful conduct on the part of the state, the court is not primarily concerned with any sort of sanction or punishment. What the court must address is an appropriate remedy to try to mitigate the prejudice that has been caused by the late disclosures. Ordinarily, a logical remedy would exist here, and that would be a continuance of this trial. This has been proposed by the state as one solution.
Okay.
And the
So
state
it's like they
is
just can't
proposed to mirror a continuance.
get it together,
in
I
the
guess.
companion
I mean,
case of the Chad Guy Daybell's case, 1623 case. However, here, that's an option that I can't consider, because in this case, the defendant has unequivocally asserted her right to a speedy trial.
there you bring up a good point.
In determining whether speedy trial is violated,
Because a
one
lot
of
of
the
times that
major
happens,
factors
right?
is the reason for the delay.
A lot of
the
times
reason for the
people
delay
get
here
weird about
rests on the
DP.
state, and can't be counted against the defendant to justify a delay of her trial in this case. If I were to delay this case based on
And calcification, I do think
an
you
issue
100%
caused by the state, I believe
revel in
that would
as
violate her
well. She would
fundamental
literally
and
be on
constitutional
death
right
row
to a
talking
speedy
about,
trial.
I am the second damn coming.
On that issue,
100%.
it's been brought up before, and I would caution the defendant that her attorneys have also cautioned her that by insisting on going forward with the trial now, knowing there's additional evidence they are not prepared to address, that's a risk. And the risk, I believe, has been discussed by counsel and by the defendant, and the decision as to whether or not to continue forward without a continuance is a decision only the defendant with the competent advice of her counsel can make. The issue's been raised before, and again, there's never been a waiver of speedy trial, so we're scheduled to start with jury selection next week, and that's when we're going to do this trial. The court sees then the remaining options then as either somehow sifting through this evidence to determine what should or could be excluded. I could also follow the defense recommendation of just carte blanche excluding significant portions of the state's case as a sanction, and I've considered that. The court also finds that given the statements of both the defense and the state, it would be impractical at this late stage, with trial starting next week, to be able to go through this evidence in a piecemeal fashion to determine what comes in or what would be excluded. There's simply not enough time to go through that exercise. The court also finds the defense request to exclude numerous witnesses and much of the state's evidence would be an unreasonably harsh sanction, denying the state of its right to bring the defendant to trial on evidence that's been previously disclosed. So that means there are two remaining options to consider: striking the death penalty or dismissing the case. The court determines that dismissing the case would again be too severe of a sanction here,
Can you imagine if they
given that the
dismissed the whole
court
damn
finds the
case?
state has in good faith attempted to disclose all discovery, and with a clear determination here that the state has not acted in any way in bad faith. Courts considered further the state's objection as it relates to an argument that this issue is not ripe to be considered at this time, that perhaps the court should wait until a verdict comes in to determine whether or not the death penalty should still be instructed to the jury in this case. I don't find that to be a persuasive argument. I think it is a ripe issue that's before the court now and needs to be determined before trial begins. There's a case I'll cite, United States versus McGriff, 427.
I'm right, Veronica. There
Second,
really would be.
2006 New York
People would
case
lose
that
it.
says, moreover, there are practical reasons weighing against the post-trial assessment to conduct a capital case. Only to strike the death penalty notice afterwards would be a colossal waste of time, effort, and expense for both litigants and the courts. Finally, then, the court considers the defense argument that the death penalty should be stricken as a discovery sanction in this case. The court notes that it is the sole province of the prosecution to exercise their discretion in determining what charges to file, and in this case, whether a notice of intent to seek the death penalty under Idaho law is warranted. Being mindful of that, the court has sought to consider any other reasonable alternative to interfering with that prosecutorial discretion.
Like during this, I would love to
previously
know.
mentioned here,
She's just
all
sitting
other
there
options
smirking while he's
have
talking
been considered
in the
before
courtroom.
determining whether it would be
You know
an
what I mean?
appropriate
Things like
sanction to
that.
strike the death penalty.
They didn't get far out the gate.
First, and
where they're
again,
like
the court would
yanking the
note that
camera.
there's a heightened level of scrutiny
You can't have the
and due
cameras
process
in the same
protection
room with
afforded
her
a
during the
defendant
trial.
in a death penalty
Drama.
case.
Right. I mean,
The
they were just like,
statement
nope.
death is different has been cited many times by the defense in this case, and it is in fact a legal maxim coming out of a federal case called the Furman case. The U.S. Supreme Court summarized in some of these decisions another case called Sparklane versus Florida, and they noted that in post-Furman jurisprudence, continuing to recognize that, quote, death is different. In the 12 years since Furman, quote, every member of this court has
She's
written
totally
or joined at least
smirking.
one opinion endorsing the proposition that because
You
of
already know this,
its
right?
severity and irrevocability, the death penalty is, qualitatively different from any other punishment and hence must be accompanied by unique safeguards to ensure that it is justified response to a given offense. The U.S. Supreme Court has on occasion relied on this difference as the basis for upholding procedures in death
I
cases
know,
that are
right,
not
Lolo?
required in other
I'm not
cases.
gonna lie, like, you want to talk about, if y'all
There's
like,
other
know what
sites that
ASMR is,
cite
like,
to a
I'm up here like
heightened
this right now, I'm
fairness
like,
and heightened reliability standard that comes along with capital
this guy is like
cases,
a bedtime
and
story.
also a
Oh
fairness
my
in fact
gosh, but it's
finding.
great audio.
And that would
Great
be,
audio,
for
right?
example, the Reed
Clear, crisp.
versus Convert case. In that case, the U.S. Supreme Court held that, quote, in capital cases, the balance of conflicting interests must be weighed most heavily in favor of the procedural safeguards of the Bill of Rights. And in a different context, the U.S. Supreme
Bueller.
Court in Gardner versus Florida held that due
Bueller.
process was violated when the death penalty was imposed
Bueller. Yeah.
on the basis of a confidential informant, which was not disclosed to the defendant or his counsel. So the case law from the United States Supreme Court is clear that, in fact, death is different. The court here has to consider whether there is any precedent in Idaho for this proposed sanction. While the state of Idaho, well, there isn't in the state of Idaho. I'll just state I haven't found any case where this has been
I
considered
agree,
or ruled
Sarah.
on.
I'm all for keeping
However,
them.
as I mentioned,
This is
the
going to go on for
sanction
so long.
has
This
been
case
recognized
which
and
is
upheld in other
sad
jurisdictions,
for
including
the
federal
family
courts,
members.
and they've recognized it as an
Larry,
appropriate
Kay.
remedy.
The poor
There are
children
reported cases
still
in
haven't
other
been
jurisdictions
addressed.
where courts have
I mean, my
determined the
God,
striking of the death penalty to be an
that's
appropriate
such a
sanction.
slap in the face. I mean, it's
Notably, in the
sad,
federal system,
heartbreaking. Can
there's
you
a different
imagine
procedural
living
mechanism
through
required
this?
of
They
the
haven't even been
government
able to have a
to
proper,
go forward with the death
you
penalty,
know,
and this procedure differs from
burial.
Idaho. Some of the federal cases detailing why the death penalty was stricken as a sanction explain a failure of the government to comply with that procedure. In those cases, the court discusses a showing of prejudice as a threshold, quote, to bar the government from seeking the death penalty. And that's from a case
They really
U.S.
have,
versus
Irene.
Rivera Clemente. The rationale, however, behind both that federal procedure and the issuance of a sanction would apply to this case. Some of the quoted language from that United States versus Rivera Clemente case, which is cited DPR September 19th, 2012. That stated that part of the citation there, we agree that the prosecutor's failure to provide timely and full disclosure of all statements has caused prejudice to the defendants. And then they stated that in a death penalty case where the stakes are so high, a smaller quantum of prejudice may justify a sanction. And in that case, the sanction was the striking of the death penalty. In this case, the trial court here, I'd cite to a case, State versus Morales, which is a Connecticut case, 232.
And see, now we have to wait for
Connecticut
Chad.
707, a
I mean, it's
1995
just,
case.
you know,
The trial court should not be faced with the Hobson's choice of either dismissing all criminal charges or denying any relief whatsoever to a criminal defendant who possibly has been prejudiced as a result of the negligence of the state. Instead, the trial court should determine the appropriate remedy in an exercise of its discretion. And then quoting another case, State versus Tiedemann, 162, P3rd, 1106, which is a Utah case.
Excuse me.
The touchstone for the balancing process is fundamental fairness. If the behavior of the state in a given case is so reprehensible as to warrant sanction, a sanction might be available even where prejudice to the defendants is slight or only speculative. If prejudice to the defendant, on the other hand, is extreme, fairness may require sanction even where there is no wrongdoing on the part of the state. In between these extremes, we have no confidence that trial judges can strike, or we have confidence that trial judges can strike a balance that preserves defendants' constitutional rights without undue hardship to the prosecution. So that case says to look at weighing out the balance of prejudice versus any misconduct of the state. And again, I haven't found here any misconduct of the state. However, procedurally, disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally, even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit
witness
of
list
the
was
mitigation
and
person
I don't mean
who
to
has
say it
said
was
unequivocally
amazing,
they simply
like in
cannot have
that
time
kind
to
of way. That
prepare and go
sounds bad.
through
It's the wrong
for
word,
mitigation
but
the late disclosed
in the
discovery.
context of,
Thus,
I think
considering
it's going to
everything, the
be
court is required to
hard
fashion a
to
remedy
if that makes
that
sense.
honors the rights of the
It's
parties,
going to
the
be very
fundamental right to a
insightful.
fair trial,
Best way to say it.
and the right of the state to bring to trial those who are accused of a crime. In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded
I mean, this
from
is a
seeking the
major
death
win.
penalty at trial, and the state's
Like
May
old Soul
2nd,
just said, her defense is
2022
fine hard for it. I
notice
mean,
of intent to seek the death
like it or
penalty will be
not,
stricken.
major win for the defense
To be
here.
clear, the court does not
Major
impose
win.
this sanction to penalize the state, but rather to
All
ensure the
because of missed
constitutional right of the
deadlines.
defendant is
You
protected,
know,
allowing for a reasonable defense to be prepared for this trial. In addition,
here's the
this
thing.
court will keep under advisement
Hold
any
on,
further
let me get it
objections
done.
that may be lodged in the form of motions in limine that will come either before or during trial to consider whether any late disclosed evidence should be excluded in an attempt to remedy the prejudice that may have resulted from these late disclosures. Finally, a couple of points on that decision. There was a late filed emergency motion yesterday that related to this. The court had reached this determination and determined this to be the appropriate remedy prior to reviewing that, and in fact did not consider any of the issues raised in yesterday's pleading in making this determination, and I'll consider that pending motion moot. I'll also note that the ruling here applies only in this case against Ms. Ballo, the 1624 case, and in no way impacts or affects the companion case 1623, because that defendant has been provided additional time to prepare for trial and to review additionally disclosed
Isn't he
discoveries. So it
just
has no
hating
impact
his
on
life
that
right
case.
now,
So
Mr.
without that
Chitty
concludes
Chud?
the court's oral ruling on the motion to strike the death penalty, granting.
Okay, so that's it. Where it's over. I mean, my God. I mean, bless his heart. I mean, come on. Oh my gosh. Okay, let me wake back up. You know, whew. God bless the jury. I mean, can you imagine him reading off, like, you know how the judges do, like towards the end, where they're like, I'm going to explain all this stuff to you and read your thing. I mean, I'd be like, dude, you're losing me, right? Especially like if you came back from lunch or whatever and it's like warm in the courtroom, I'd be like, I mean, you know, but again, so here's the thing. Major win for the defense. Major win for the defense. I did not know, and this is why I did want to listen to it. I didn't know that it was because of the reasons he just cited, right? I'll bet you this prosecution is like, ooh, sorry. I mean, I didn't know it was over that. I just think that they're in over their heads. I think this is a massive, massive case. The likes of, I don't know if we've ever really seen this before. I mean, it's so, the web of it, it's so crazy. You know what I'm saying? And so, again, I do think it's like, I don't know if funny is the word or weird, whatever. Chad's punching air in his cell. Chad's punching air, right? And again, it just kind of, I think, comes down to how you might want to live your days out, because I personally don't think either of them will see the light of day. There's so much legal stuff they're going to be going through, whether from this state to that state, this state, that state. So it's like, this is just going to go on for years and years and years and years and years. And the next state might be like, you know what, like, especially with Lori, go on, fire will spark you up. Y'all didn't get her over there. We'll get her over here. You know what I'm saying? Like, you never know. But yeah, she is probably in her cell talking about, I told you it's going to be good. It's happening. You know what I'm saying? Like, she's thinking that Earth, Wind, and Fire are coming to rescue her from the thing. That's what really burns my biscuits about it. You know what I'm saying? Like, she's probably thinking that, like, her portal prayers are being answered or something. I don't know. But yeah, my mouth is kind of on the ground finding out that it's from the prosecution. I mean, I'd be embarrassed to go to work the next day. I'd call out sick. I'd be like, look, I don't know what I ate last night, but I can't make it. You know what I'm saying? Like, I mean, come on, right? Um, wow. But you heard the judge say, like, look, I've worked with both of these people, Archibald, them, it's not nefarious, it's not this or that. It's just, it is what it is. They have not made these deadlines. And again, I just think the case is so huge. I mean, it's massive amounts of information. So but I mean, I guess that's where I'm just like, I mean, it's been going on for years, but there's just so many different things that go on with it. So I know, right? Mel said she probably thinking the Zulema had something to do with it. Lord knows, she's like, yeah, Zulema's done, sent a damn, tornado this way or something, twisted my way out of it. So anyways, so y'all, I've got to go because I'm going to fall out. That was like the nightcap right there. We're listening to that guy talk for 30 minutes because now I'm like, I mean, look at my face. I'm like, so thank you for joining. This was a blast from the past. We have a little special guest real quick. Hey, what's going on? If you're watching from the replay and you're still watching, thank you. But for everybody watching, drop hearts down in the comment section for all the victims of these cases. In all three of these cases, the victims happen to be very young people. And this is Oliver. He's just visiting. He's just taking a visit. And so that's it. Thanks for joining, everybody. Emily, thank you, everybody. Everybody give Emily a shout out and a thank you for holding the fort down, for keeping the cushions fluffed, the doors open. And that's it. We might do a live tomorrow to go over day 3. I'm not sure yet. We'll kind of see what the vibe is. Tons of other stuff pops off, and we might do something like this. Obviously, once the actual trial of Leticia starts up, it'll be a little bit more, in there, but whatever, we'll see. So anyways, thank you, everybody. I do appreciate y'all. I appreciate you, Emily, for holding it down, and I will talk to y'all soon. Y'all have a wonderful night. Sleep tight. Don't let those bed bugs